last thing in here. Because Big Ranch, and one of his very best kids, Bert Nieslanik, now in Grand Junction in private practice. Please welcome.
Our subject is theories and themes, but let me back up for just a little bit, because you're not here just to hear about theories and themes. You're here to figure out how to win more criminal cases. Bert? That's what this seminar is about. Theories and themes, and what we're going to be doing during the next 2.5 days happens to be, I think, a tremendous program that's going to help you win criminal cases. Let me parenthetically say that as I go around the country lecturing to people, as I watch people trying cases, and as I watch cases on court TV, and I hear people talk, there is a great deal of pessimism around about winning criminal cases. And there's a reason for this pessimism. One, let's face it, the courts don't do what they used to do. In 1966, I started trying criminal cases in the public defender's office. We would, when we started a case Monday at noon, listen to what new cases had come down to the United States Supreme Court that would be useful to the defense in winning the case. I understand that's not the case anymore. But it is because we are so law-oriented, I think, to a certain extent, that we have become pessimistic. Yes, the judges rule against us. And the truth of the matter is, back in 1966, when we had Miranda, MAP, when we had the identification cases, when they came down, it didn't do us all that much good. Where it said in Miranda that we are not to assume that there was assent, the judges could always hear that the defendant had assented. There was always a way that the judge ruled against the motion to suppress, even back then. But what it caused us to do, public defenders, criminal defense attorneys, is to become so much into the law and winning on the law that we forgot about cross-examination, we forgot about closing argument, we forgot about voir dire, we forgot about opening statement, we forgot about theory of the case, we forgot about the factual things that win cases. And I might say that that influence continues today. It continues for a number of reasons. And one of the reasons that it continues is that you all went to law school. And if we achieve removing from your guts the terrible crimes that they committed against you in law school, we will have succeeded in this program. These people are people who themselves don't know where the courthouse is. They have never been in a courtroom, and they were telling you how to be lawyers. And what it caused you to do is to become legal analysts. All of the creativity was removed from you because you were not to create, were you? You were to take a legal rule. Rules for 3 years, endlessly and mindlessly. Rules. And you were to memorize these rules, and you memorized these rules. And you wrote them down on an exam, and then you walked out of that exam room, and you emptied your head to get ready to put the other rules in that you were going to need for your exam the next day. How many times was the word persuasion ever used during your law school careers?
Other than in extracurricular activities.
There's the burden of persuasion that they mentioned, but they meant that in a legal sense. And so they did you very, very great harm. When I hear lawyers talk today over a cup of coffee, they are engaged in legal analysis. I don't hear them discussing how it is that we're going to persuade the jury. And for today's purpose, these folks right here on the first two rows are going to be my jury, okay? They have been to law school, but for today, you have never been to law school, okay? You're bricklayers, you are typists, you are middle management, you are in business, you are workers, you are anything but lawyers. For one thing, what do you think of lawyers? Now that you're not a lawyer, what do you think of lawyers?
They're assholes. I just went through a divorce. They're out for your money. They don't give a shit about you.
What about truth?
They're not in-
Truth is irrelevant, right, to lawyers, okay? And we have been, in their minds, in law school for 3 years learning how to cross-examine, put words in witnesses' mouths and so forth, right? To screw around the facts. We are anything but truth seekers. Let's recognize that that's where the jurors are. And above all, they do not go back into the jury deliberation room and conduct a legal analysis where they list all of the elements. And then they go through these elements one by one. And they say, did they prove element number 1? Beyond a reasonable doubt. Did they prove element number 2? Beyond a reasonable doubt. And if the answer is yes to all of these, we don't care whether the person is guilty or innocent, or whether we want to send him to prison or not. We don't care about that. We have gone through the legal analysis. If there's anybody here who believes that that's the way it works, I need to talk to you at the break, okay? These jurors are going to do what? The right thing. And the right thing doesn't have too much to do with the elements and the burden of proof. Now, these things get close. They have something to do, because if there has been a lot of proof and they're convinced that he's guilty, then their right thing becomes to convict. So, a couple of points. 1, we can win criminal cases with regularity, but we have to make a switch. It's a paradigm switch. It is a very significant switch. It is to take the method, which is the standard method of trying cases around this country, and dumping that method down the toilet. Instead of being lawyers, that we become persuaders. And that's a very, very different thing. Let me tell you a little story that illustrates. It is of a civil case, Michael Jackson's case. In Denver, we had a young lady named Crystal Cartier. Crystal Cartier wrote a song named Dangerous. Wasn't very successful. Later on, Michael Jackson wrote a song named Dangerous, which was successful. She heard the song, Michael Jackson's song, Dangerous, on the radio and decided that Michael Jackson had taken her song. She sued Michael Jackson. I was working with the law firm that was representing Michael Jackson. And they had a mock trial. And at the last minute, they invited me to the mock trial. And I go there, and we've got mock juries, older people, younger people, etc., on the jury. And the way the lawyers, okay, we got this distinction in mind between lawyers and persuaders. The way the lawyers put this together for the mock jury was, we will play the two songs and we will ask the jury what question? Whether the two songs are substantially similar. Okay, you're not copyright lawyers, but substantially similar means a lot to a lawyer, not much to a persuader. Okay? They played the two songs. The older people said what? They were substantially similar. As a matter of fact, everything that you young people listen to, rock and roll, is substantially similar. It is all the same nonsensical crap, okay? I mean, you didn't put it that way. And the younger people said, well, these songs are not substantially similar. And so we had a hung jury, but I can tell you that we had a dull, sleepy jury. Can you imagine deciding the question substantial similarity? Huh? I'll bet right now it is really moving you in your guts, right? When I say substantial similarity, it just moves you. And you become emotionally involved when I say substantial similarity, right? So I said to the young man, who is a lawyer, not a persuader, I said, ask the jurors if Michael Jackson stole Crystal Cartier's song. He, being a good lawyer, couldn't understand the significance of that, and what did he do? He said, ladies and gentlemen of the jury, let me ask you an additional question. Did Michael Jackson copy Crystal Cartier's song? Right? Is that good lawyer stuff? Law professor would give him an A for that. I'll bet that really moves you, right? The word copy. What? It's none of this. Ask them if Michael Jackson stole. I don't care whether you use steal, stole, stolen, what have you, but that has to be the word. Didn't understand why, but he asked the jurors if Michael Jackson did steal Crystal Cartier's song. There was an immediate change in the body language of the jurors. And every one of them said, absolutely not, he did not steal Crystal Cartier's song. Okay. And the way that it came out in the newspaper at the end, which showed that I was able to finally convince these people to use this as a theme, was, it said, jury rules Michael Jackson did not steal song. And that's what you're after. The persuader uses words like steal and stolen. He didn't do it. The lawyers use the words that persuaded law professors back when and allowed you to get through law school. And there is such a difference between the two ways. Okay? So during the next 2.5 days, and then on forever, I ask you to be persuaders, to be thinking about what it is that causes these jurors who have never been to law school to give you the verdict of not guilty. Very, very different from the lawyer standard approach. Now, so we get rid of the old method. Okay? There will be parts of you that will say, no, this old method, it's like an old shoe. It's really comfortable for me. And it should be. 3 years of this nonsense being propagandized. And then after we get out, we impress people by speaking legalese, don't we? It's an intellectual thing to do. That's not the way jurors decide cases. Every psychologist will tell you that the important decisions are made 90+% emotionally in the gut, and then the person rationalizes that decision. I've talked to a number of psychologists about this, and every one of them says, well, 90% is too low. It is more than that. Juries decide emotionally. Now that we have been taught as lawyers to condemn deciding things emotionally as being bad, right? It is bad to decide things emotionally. I wish I had more time to make the case that the decisions that people make in their guts, with their feelings, are far better decisions than those that are made supposedly rationally. I will tell you that the method that the law professors have is not a rational proceeding, and I can show you. You put all of these things together and it doesn't make sense. Prediction is how you judge whether some legal theory works. They cannot predict how cases are going to come out nearly as well as Bert can, Bob Pippin, and the other people who are going to be here before you. Because we work as you do on the basis of what experience teaches us about how people are likely to think. Okay? So, this emotional approach, this judgment approach, this operating on the basis of gut, of all of the factors that enter into it, that approach makes a heck of a lot more sense than this supposedly rational approach of the law professors. And only when we get out of trying to use that kind of approach and get into the approach of asking ourselves, what is it that will move these jurors where they live? Only when we do that can we become great trial. Happens to be a friend. He'll look you in the eye and he'll say, I'm not proud of it, but I don't know evidence. If you've ever seen him argue an appellate court, in an appellate court, you know that he doesn't know law. What does he know? People. Huh? Would we agree? That's all his focus is. Now, I'm not telling you if you can win a motion to suppress, don't bother to do it. I'm not telling you that. You can win on the law, that's fine. But the great majority of cases, you are not going to win on the law. You are going to have to do it with the jury. And that jury consists of people. And that jury thinks differently from lawyers. See, we spent 3 years learning to persuade law professors. Is that true? Right? To give us grades. The vast majority of lawyers do is that they get out of law school and they continue to try to persuade law professors because that's what they were trained to do. In 200 trials, I have never had a law professor on my jury. You can count on it, there will never be one on my jury. As a matter of fact, I've never known one to be on the panel. So we have to switch from persuading these people whose minds are so screwed up, persuading people who think like people. And when we do that, we can win criminal case after criminal case after criminal case after criminal case. Using the lawyer method, legal analysis, getting up and doing that for the jury will win you some cases, but not very many.
I actually had a question from something, Stephen. How many of you have ever won a theft case on the law? You can cheat and lie and hold up your hand if you'd like. Okay, how many ever won a theft case on the law? I did once. Come on, there's two of us. We should get together later. How many of you ever won a burglary case on the law? Couple. How many of you ever won a drug case on the law? How many of you ever won a murder case on the law? You can't. because the worse the case is, and the worse the facts are, and all those kinds of things, the worse your chances of winning on the law. I don't know the law either. And I don't really care. I have one of those computer things, and you can find some law for everything that you want if you put in the right words. And I don't really spend a whole lot of time on it. And I didn't do that well in law school. I'm a proud steam of being in the bottom quarter of my class, and I'm proud of it. That's what got me into the public defender's office. That's the great thing about Colorado, wicked stepchildren. But that time that I spent on the law, or could spend on the law, I go talk to my grandmother. She's 96, and she helps me with every single one of the cases that I try, and all those that I'm getting ready to try, because there's one thing my grandma knows. She knows a lot of people, and she knows about a lot of people, and she has really great ideas of what makes people who are sort of her age, lots of people 16 over on your juries, lots of people 16 over on my juries. They're the only ones that come to jury duty, right? So she knows a lot about what makes those people friends of yours, because she's a believer that no one trusts a stranger. And when you stand in front of a jury, that's what you are, is you are a stranger. So your first goal is to not be a stranger, so they'll trust you. 3 rules. They like you, they trust you, and you be entertaining, and you'll win. But it's kind of that simple. So think about those cases that have the worst facts. And what Steve and I want to do now is kind of go through a hodgepodge of things to consider when you're putting together your theory. These are not rank ordered, although a couple of them we put together because they kind of belong together. So you don't have to write them down. Believe me, you're going to remember. Okay? All right. I want to do a couple things as we go along. I want to give you some theories, and sometimes they will be themes, which you'll learn about next, that I've used in some of my cases, or that I stole from other people. You can steal all you want. This is like open license on stealing, right? And then you can call it your own. Don't ever tell that you stole it from me. Just say it's yours. So you can plagiarize, copyright, all that stuff. So as we kind of go along, I may use some exhibits or show you some things. For example, a burglar. Anybody get emotional about a burglar? I like burglars. The burglar wore a size 12.5 shoe and smoked. He was a large, smoking burglar. Joe Jarvis wears an 8.5 shoe. He's never smoked a cigarette in his life. He's not a burglar.
So if we're thinking about these cases, we're going to need to think about the jurors, okay? The method I suggest to you, I call the power persuasion method. Persuasion has one important principle. There's much more to it. But it is this, that I no longer think in terms of what Steve Wrench thinks, or what the law professors think, or what my fellow lawyers think. I think only in terms of these people and what they think. Persuasion is not about the persuader, it is about the persuadees. There is in Dale Carnegie's old book, How to Win Friends and Influence People, a cartoon. And here is a fisherman, and what is he using for bait? Strawberry shortcake. Okay? And it's the wrong bait. So we have to think in terms of these people who want to do the right thing, who have, if you read what the psychologists say, and experience teaches, certain universal principles and values. And those universal principles and values are fair, that apply to us. Fairness, justice, and truth. That's what they're interested in. in doing the right thing. We convince them that we are on the side of fairness, etc. I know you're going to say, wait a minute, what about the guy who is caught with the money in one pocket and the gun in the other and so forth? We'll talk about that. There is no case where I've ever had to waive the closing argument because there was no theory of the case by which the defendant was innocent. Okay? Those are things that can persuade jurors. Now, we change our thinking. Okay? Hear me. When I prepare a case, what Steve Grinch thinks is totally, completely irrelevant. It makes no difference what I think. It makes no difference what the law professors think. It makes no difference what the lawyers that I talk to think. I will tell you that when the lawyers in the back of the room who come to watch the trial tell me I'm doing a great job, I get terribly concerned. Because if these people who are so screwed up by 3 years of propagandizing are believing I'm doing a good job, unless they're just doing it through quiet, I'm in a great deal of trouble with the people who count, the only people who count. So, our case is going to be built for the jurors. Now then, what kind of case does it take? Okay, we need to think about what is the persuasive case to whom? The jurors. And I know that I'm driving this point home awfully hard. I'm driving it home awfully hard because wherever I go in this country and I try to go watch a trial, I find that the great argument being made is what? The prosecutor, you have to be the prosecutor only because of where you're sitting. The prosecutor has what? Failed to prove, help me out. The prosecutor has failed to prove each and every element. Beyond a reasonable doubt. Yes, the prosecutor has failed to prove each and every element beyond a reasonable doubt. Now, please understand, I am not blaming the people who used that argument. You were taught that argument. It was internalized. It was driven home to you, not only by the law professors, but by the people who were the product of the law professors, that is, who happen to be older than you and tried more cases. They're trying cases on the basis the prosecutor failed to prove each and every element beyond a reasonable doubt. I will tell you, I know an awful lot of the great trial lawyers in this country, the great criminal defense lawyers in this country. There is not a single great criminal defense attorney in this country who uses that argument as the central theme of their case. Not one. Why don't they use that as the central theme of their case?
Because you're admitting guilt.
You're admitting guilt. Is that fair to say, ladies and gentlemen? When I make this argument, now hear me, you're jurors, you're jurors completely here, but the rest of you haven't been to law school. I make this argument. The prosecutor failed to prove each and every element beyond a reasonable doubt. In my own mind, is my defendant guilty or innocent?
Guilty.
He is guilty. Because what? Is that the argument I would make if my client were actually innocent?
Or if you love him.
Or if I loved him? That's not the argument I would make, is it? It is like your child. Your child is accused of being in the cookie jar. And you accuse the child, and the child says, you can't prove it beyond a reasonable doubt. What would you do? Okay? You know that the child got into the cookie jar, right? Just as the jury knows. Now, you may still win because the jury goes back there and still they want to do the right thing in spite of the fact that the attorney has really essentially confessed. And they go back there and they may still let a defendant go because they think it's the right thing. But it will not be because of this great argument. Now, What is wrong with this argument? I mean, it confesses. Secondly, what? It is not, what's this about? I wish I had a chart here. Everything you do in preparing for a trial and during the trial is gauged on the basis of persuasive power. It has persuasive power or it does not have persuasive power. Does this argument, did you hear me on the everything? Huh? This is a simple game in certain sense. Everything is based on whether it has persuasive power or does not have persuasive power. What do I mean by persuasive power? Kind of an abstract term. It is the power to move this juror in his gut to give you the not guilty verdict. That's what you're looking for. So, when I make the argument as the central thrust, now hear me on this. I don't say that you don't talk about the burden of proof, etc. But every time I talk about it, I want to do it in terms of the burden of proof being on the prosecution, beyond a reasonable doubt, unanimous jury if you still have it, and the presumption of innocence. All of these being protections for what? Or against what?
Innocent people being found guilty.
Say it out loud.
They're protections against innocent people being found guilty.
That's right. That's what they're about. See what we have been trained to do? We have been trained to spout a legalism as our major premise and assume that the jury understands the significance of that, and they don't understand the significance of it. Usually I don't get any answer to this. During the voir dire, everything about all of these different legalisms is based on the idea that these are protections, ladies and gentlemen. Yes, of Johnny defendant, but of also for you against convicting innocent persons. Because from the standpoint of persuasive power, what counts with the jurors? What counts with them? What is going to shake the hell out of them if they find later on? Huh?
That they found an innocent man guilty.
That they convicted an innocent man. The great weapon. The very great weapon for the criminal defense attorney. And there is no more powerful weapon that anybody has in all of trials, is the fear of convicting an innocent man. Right? We said that people operate emotionally. It's the fear of convicting an innocent man. And you must create that fear of convicting an innocent man.
I'll give you an example. Ladies and gentlemen, each investigator in these 3 pipe bombings had their own list of suspects. This was Larry Chrysler's list. This was Charles Gallion's list. By the way, there were 30 of these. I couldn't remember. Jimmy's name is nowhere on any list. He doesn't appear on anyone's list. He only appears in this chair, marked with him. See the example? I mean, the example is if there are all of these suspects that were on lists, how do they get to you? Now, I'll tell you how this kind of came up, because I want to jump back to one thing that you said. One thing that I think are really good of you, how many of you have been or are or thinking of being a defendant? Or hoping that in your next life, you don't have to be a public defendant. Did you ever get that stack of discovery, the 30 different cases that are all put together with clips, and before you go home you have to read through all the discovery and all the cases because they have prelims of 2 days or less? Been there? Okay, so you start through it. And one place I think we're really good about persuasion is when we read the discovery and you're reading through what the victim said, you get in your mind the way the prosecutor is going to present that testimony and how you're going to lose. So you can characterize that in a very persuasive way when it's the bad facts against us. And one of the things that I hope that you're going to learn in the next couple of days is, because we always kind of make it worse. You know, she gets on the stand and she's not really that good. Occasionally she's better, but she's not really that good. It was worse in our mind than when we finally went and spoke to her. You know that feeling? Okay. So we're good at making something, picking out how something can be very persuasive to a jury. But we first start on the other end because we read all the bad facts first. I mean, that's all you get in that discovery is the bad facts. And in these 2 days, I think what you're going to learn is that you can seize something. Okay, you can seize something to build your case around that makes your client not guilty. Remember, your client has a constitutional right to be not guilty. I mean, that's the legal argument I make. Judge, I get to get this evidence in because my client has a constitutional right to be not guilty. Well, Mr. Nieslanik, where is that in the Constitution? All of it. Every single bit of it. I mean, that's how little I know about the law, right? And he goes, constitutional right to be not guilty. Sounds good to me. So you can find something and make your client be not guilty. I want to start through the list because the part that always made me and still does sick, you know, like the throw kind of sick, is that one bad fact that never changes no matter what you do, no matter how you think about it, no matter how you structure your case, no matter where you're going, you've got that one horrible bad fact beyond change. And I'm hoping that one of the things in my group I can convince you to do is the sort of Spartan warrior thing of that bad fact beyond change. We'll find it, we'll pick it out up, and then I do kind of the Zen Buddhist approach to it, you know, and just hold it to you and love it to death. And maybe you can turn it into not a bad fact. I mean, sometimes great. Is this a swearing seminar? Okay. You can really turn it into some great shit. I mean, it can turn into some really amazing thing if you're not afraid of it. But you see lawyers in the middle of trial, and they step up there, and they're asking questions, and they're on a roll, they're going to bang, 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 and then the witness says that one bad fact beyond change, and they kind of go, they just kind of stop because they're not prepared for it. But you know, a knife might not be the worst thing that the jury ever sees. The gun might not be that little sawed-off shotgun that has Hell's Angels in the handle. Might not be the worst thing they ever see. I mean, it may not be that way. So if you'll embrace at least that one in the beginning, and I always do it first because it makes me sick. You take that one bad fact beyond change, that bundle of bad facts beyond change, and really spend some time with them, and sit with them, and work with them, and look at them, and handle them, and do things with them. Put them inside your jacket, and whatever you have to do. And I don't mean try to change it, but really get used to it. Then you can start seeing it some other ways. So my own personal advice is that when you start into your constructing your theory, and Steve's going to talk to you for a minute about legal theories, because I always skip over that part. I don't do the legal theory. I go straight to the field theory. I go to the field theory. Okay? So I start with that bad fact, that bundle of bad facts beyond change, because otherwise, I'll get my ulcer. I just have to start there. So that's where I start. And what we're going to do is go through that. In this same case, we had a bad fact, and the bad fact was a vehicle. The same vehicle that showed up in all three volumes was aren't these cool? Come on. And so you can talk to the witness, and could you describe the car to me? So she describes the car. You take it, and you stick it right here under the bottom for the 14. Cool. $23 this is. But the same vehicle started to show up. Okay? Bad fact. It was only months of dealing with this same vehicle that we figured out that one of the names on the list had a vehicle that looked amazingly like that vehicle that kept showing up with all the bombings. So that bad fact over time became really our best fact. That's when your stomach puts hurting all of a sudden. It's like, oh, I made some of that bad fact. That's pretty good. So start there. Isn't it? Am I wrong? Does it scare anybody else to have one of those bad facts beyond change? Yeah, if you have that feeling, it immobilizes a lot of people. They go, I don't want to do that case. So they start ignoring it. They procrastinate. You know that's the one that's going to trial. You know it. The bad fact may be 4 prior criminal convictions, felony convictions. You ignore it, and you set it over here and say, I'll come back to it later. You come over, I'd rather do 1,000 rapes than that one case, you know? And all of a sudden, here you are, just 3 days before trial is done. It didn't change. You just have less time to deal with it. So, you know, pick up the old bad fact, you know, take it, drink it. Why don't you and I go drinking and see what we can figure out, you know? Or take it home, or do something. I take it to my grandma. Grandma, what do you think of this bad fact? It's not terrible. She goes, well, it didn't look so bad to me. You know, dress it up a little bit. We'll make it look a little better. So start there, because in the 12 and a half years I spent at the public defender, I lost more sleep over those bad facts that I ignored than when I started dealing with nothing. So on to constructing our theory, keeping in mind we're going down the road with that bad fact assumption. Okay, perfect. All right, Steve, sure.
Okay. Let me give you some kind of definitions that we'll be playing with during the next 2.5 days and then on after that. She said I was going to spend a minute on the law, and I won't. What we're talking about there is what we call our defense. Our defense is self-defense. Our defense is consent, this, that, and the other thing, okay? But that's not what the case is about. It is true that we are going to come up with a theory of defense that does fit within the law. But those things are not the difficult part. The theory, when we talk about it during the next 2 days, the theory of the case, the theory of the defense is going to be what Bert pointed out as that which makes your client not guilty, okay? Makes your client innocent. In the identification case, the witness made a mistake. In the consent case, she did consent. It happened.
And then she made a mistake.
And then she made a mistake because we're looking for the motives, etc. If we get off into just the legal stuff, we are not going to be persuasive. Because as I look at my jurors here, I find that the law does not move them in their guts. Okay? We want to find that idea, those facts, the way it fits together, the story that makes it so that the jury has this fear of convicting an innocent man because we have a positive case, often made directly out of the prosecutor's case. As a matter of fact, the vast majority of times made right out of the prosecutor's case. Okay? The developed theory, and that's what we're going to be dealing with the rest of our time, is having that, whatever it is that is our theory of the case, and then the exhibits, the rhetorical devices, the themes, the ideas, all of the facts put together that support that theory. You can't go to trial saying that my theory of the defense is that it's self-defense or something like that. You need to have a developed theory of a factual case, not just legal, factual case.
Example.
That's where it really is.
Example. Don't sit down, Steve. It's a very short example. 2 boys, 2 moments, 2 punches. What's it about? 2 boys, 2 moments, 2 punches.
Self-defense.
Is it a big self-defense case or not?
No, 2 punches.
Not with 2 punches. There's no reason that boy should have dropped dead, right? 2 boys, 2 moments, 2 punches. That's the theory. That's the theme. And that was the headline in the newspaper. So that's how you know you have a really good theory. And that's what they print. 2 boys, 2 moments, 2 punches. It's the theory, the theme, and the facts. Totally true.
And what we often do is we stop with the legalism. And we don't put the rest of it in the development case. Theme, read a definition, words we want the jury to use in the jury room. And another way I think about it is, we know that, of course, wives on juries don't talk to their husbands and husbands don't talk to their wives. But just imagine it for a moment that they do. When the husband says to the wife, "What's this case about?" Your theme is going to be what the wife says to the husband. This is a case about. And of course, the next lecture is going to deal with the themes, but we just want to make clear that the themes fit in to forward the theory of the case like everything else does. Now, how do we go about coming up with the defense case when it isn't the prosecutor failed to prove each and every element beyond a reasonable doubt? We want a positive case that takes the position that he's innocent. Incidentally, people will say to me, but I can't put. Your theme is going to be what the wife says to the husband. This is a case about. And of course, the next lecture is going to deal with the themes, but we just want to make clear that the themes fit in to forward the theory of the case like everything else does. Now, how do we go about coming up with the defense case when it isn't the prosecutor failed to prove each and every element beyond a reasonable doubt? We want a positive case that takes the position that he's innocent. Incidentally, people will say to me, but I can't put together a case where the jury is likely to say my theory is the way it happened. And you know what? You don't have to. All you have to do is to put together these facts in such a way around a single idea, which is a single organizing idea, which is your theory of the case. All you have to do is to have that be a reasonable possibility. Hear me on the word possibility. Then you are going to scare the hell out of that jury about the possibility of convicting an innocent man. Okay? You're going to scare the hell out of the jury about the possibility of convicting an innocent man. So all you need is a reasonable possibility. That's all. Along with the emotion, and you win the case. Now, how do you develop it? There are two devices. Two devices that you need. One is brainstorming, and the other is the idea book.
No, at home we call it the wrench book. In fact, mine says wrench book, and so does it, Bob? Does yours say wrench book? Mine says wrench book. It's not with a W, it's with an I. He calls it the idea book, we call it the wrench book.
Now that I've been embarrassed here.
Well, it's true.
The idea book. It is a book that is not your trial book. It is not the place where you put the documents in. It is not the place where you put the preliminary hearing transcript, etc. It is a book for one purpose and one purpose only, and that is to write down the ideas that you have for winning the case. Ideas win cases. Ideas like the theory of the case, like themes, like how you say something, like everything that we're going to be talking about. Now, the brainstorming process, let me talk to you for just a second about that. It is about creativity. You have been trained through your 3 years of law school in analysis, legal analysis. That's not what I'm talking about. If you are feeling legally analytic, you can't do what I'm talking about, which is creativity in the facts. Okay? And here's the kind of mindset that you need. It is that you are starting with an important assumption. It's not just an assumption to you. The defendant is not guilty. Okay? Our next question is going to be, how is it that he is not guilty? The fact that he is actually guilty has nothing to do with anything. Okay?
Don't forget that now. That's our big point. Don't forget that one. Okay?
It should not influence your thinking. Well, he's actually guilty anyway, and so I'm more likely to say the district attorney has a tough case. No. This is a simple-minded game for simple-minded people like Rich. Okay? It is tunnel vision. The defendant didn't do it. Okay? Now then, how is it that the defendant didn't do it?
Let me interject one.
Okay.
I make my exhibits in the first couple of weeks after I read them. I know, I do everything backwards. But I make them in the first couple of weeks after I read the discovery. They're very seldom exhibits that go to trial, but they're like this. I call this my hatbox exhibit. See how it sticks up right there? This is where this self-defense case happened. And I was trying to figure out how could I convince people with self-defense, because this kid died from one punch to the side of the face that tore the right vertebral artery, and he bled out in 20 seconds. It was icky. And they were like both 15. Okay, so I made my exhibit the first week, and I bought one of these great label makers. They cost $125, and they're really good. So I made this exhibit so that I could figure out where to put my guy and how to make this look more like a self-defense case. They're both the same height, same weight, same age, blah, 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 right? Well, guess what? Can you see? There's a 10-inch difference here, which was really ended up being the whole case. That when one kid jumped up on this circle, okay, he was 10 inches higher, which made him 7 feet tall. 7 feet tall is really big. Does anybody know? That's like those guys who make billions of dollars playing basketball because they're 7 feet tall. So when he jumped up here, he was 7 feet tall. The next 6 months, we just dealt with this 9.5 inches. And it became the entire case was this 9.5 inches, and it just became a self-defense case from this one little brainstorming thing that we did, and we made this great exhibit. I have a little lady who's 80 who makes these exhibits for me. She's really great, and she's cheap, really cheap. She can't earn more than $4,200 a year, really cheap. Okay, so think about making your exhibits before you do the brainstorming or as you do the brainstorming. This is a really cheap exhibit. It's like $12 in Virginia to help you. But so if you make your exhibits initially, do the case backwards. Start with jury instructions. I don't really know anything about jury instructions. So what I do is I start with exhibits because I like exhibits. And it's what made it a self-defense case. We built the whole case around it. So this is part of brainstorming. Exhibits in the first 2 weeks. Take it from me. It's a great idea. Okay.
Okay. Now, the idea book, the wrench book for people in Colorado. It's a book that's small. You're only going to put ideas in it. The defendant's name goes on the back. You have been distributed idea book dividers, and we won't have time to go through it, except very briefly. I say that with the 25 dividers in the book, that there will not be a single idea that you will ever have that doesn't have a place. From day one, your thinking is organized. This is in contrast to the yellow pad, where you write down an idea for closing argument, followed by an idea for voir dire, followed by an idea for the cross-examination of Officer Jones, and everybody tells me that, well, just before trial, I'm going to organize all of this. And I have never met anybody who has organized it just before trial. Okay, just very briefly to indicate what you're doing. You are writing down ideas as they come to you in the appropriate place. So, and those of you who want to look at one of them, you can come up and look at it. You can see that to do planning, that's things like get the hospital records, etc. That runs your show for you. The second one, law and legal theories, and you'll notice that that's the only legal one involved. All the rest deal with facts. You're writing down facts. You're writing down the factual issues, always from the standpoint of the jury. How is the jury going to look at this? You're writing down ideas. You write down every possible theory of the case. You write down every possible theme. You write down every possible interpretation of the facts. that is an innocent one that could win for you. Discovery planning. This is where can I get more information? Notice that the first 5 dividers are developing material. The next 5 are how you put it together. You write down ideas on attack, the opposing case. What is the other side likely to argue? How am I going to meet these? And Bert was talking about ignoring the bad facts on the other side. Seldom, I do a lot of consulting with people, seldom have they thought about what the opposing case is going to be and how they're going to beat that opposing case. But if we put our minds to it, we can defeat that opposing case in every instance. It is true that basically we are going to have a positive case, which, because of its nature, the way it's put together, will defeat the opposing case. Strategy, I don't have time to talk about, but it is things like, how is it that I am going to force the prosecutor to come over and argue my point? I'm going to do it by taking that which is strong on my side and giving it such emphasis and such power that he must come over and argue on my side. He must argue my point. The next one, juror's perspective. This is where you're writing down how the jurors in your community think. I think that the greatest study that I have tried to make is to make myself able to think like a juror. Okay? I work on this constantly. How can I make it so that I think like a juror and not like a lawyer? The jurors in the particular community where the case is going to be decided. If I didn't have a divider in there on jurors' perspective, the great majority of lawyers would not think about how jurors think about a case. Analysis and decision making and the theory of the case 9 and 10. Okay, there comes a time when you have to say, the trial is next Monday or what have you. We need now to look at all the ideas that we've written down. Which ones are strong? Which ones are weak? Throw out the weak ones. Come up with a single theory of the case. Not several, but a single theory of the case, which organizes all of the facts consistent with innocence. That's the basic position from which you are going to try the case. 11 to 15 are specific dividers. For example, if it's an ID case, you may want to have one of them that says ID case, where you study and think about how it is that this particular eyewitness, picked the wrong person. We had time, as some of you know, we have a lecture on identification that takes some hours actually. The next one, the story. And I'm sure that Joe and Denise are going to be talking to you in the next 45 minutes or so about the story and how, if you do not develop your case into a story, you are not going to have the motives. You are not going to come up with a lot of things that you're going to come up with if you do the story. The arguments. Ultimately, you're going to come up with arguments such that if it's mistaken identification, you can put mistaken identification, if we had a board up here, mistaken identification, and we're going to come up with every single fact, every single inference, every single way to say it, every single thing in this world to make this argument. And then we are going to drive that argument home through the case. It is going to be so that when the jury goes back into the jury deliberation room, they can never forget what our theory of the case is. They can never forget our themes and so forth, because it is all organized around this one idea. The next one, feeling, emotion. We must think about not only the feelings and the emotions that we want to bring out from the part of the jurors, but we must think about how we ourselves are going to feel during the trial. The strongest possible way to evoke emotion on the part of the jurors is if we ourselves feel that emotion. It's not an intellectual exercise. We need to have thought about it ahead of time. The rhetoric, rhetorical devices, the finishing touches like the demonstrative evidence, etc. And I know that our time is up. What I want to urge you is that during this next 2.5 days, you don't say, these are some ideas that I'm going to put on top of this old system. It won't work. The system that we are talking about here for these 2.5 days is not consistent with the way that cases are tried. You can't do them both. You're either a persuader or you're a lawyer. You can be a lawyer before the judge, but you can't be both a persuader and a lawyer before that jury. The easy thing to do is to write down ideas and say to yourselves, when I get back home, one of these days I'm going to think about putting these new ideas into effect. You never will. What I beg you to do, what Bert begs you to do, my friend Darrell, who is telling me my time is up, wants you to do, is for these next 2.5 days to be doing things a new and far more powerful way. Do it now. Dare to be great now, not some other time in the future, which gives you a way not to do it. It's kind of hard work to do something. Get rid of this old shoe and be using persuasion and emotion, theories, themes, and so forth. But we beg you to do it. Okay? Thank you very much.
I had a case that was all about blood spatters. I love blood. Don't you love blood in cases? I love it. So there were, oops, this is too small. There were way too many investigators, and they said that the blood wasn't where it was supposed to be. So this is a $42 exhibit that comes equipped with paper dolls. And every paper doll has a corresponding marker. Paper dolls have Velcro on the back. Are you ready? Here is the blood spatter analysis. If you've ever seen it, it's very boring. The first person who arrived on the scene was Bob. He got his own paper doll. So I said, Bob, I'll tell you the theory and themes in a minute. I said, Bob, huh?
You can show them the exhibit.
Okay. Bob, come show us. When you got there, where did you go and what did you do? He took his marker and came over and said, well, I went in here. And so you say, oh, didn't you investigate that corner? Oh, yeah, I walked through here 6 times and blah, blah, blah. Well, first there was Bob, then there was Auntie, and then there was another investigator, and then there were some more, and there were some more, and the word was all over. It was a Chinese wrap-up. You didn't get it. I didn't know. Well, all the blood got marked off and moved around and things like that. But we were able to show it with all of these different layers of people. So, hey, keep this in mind, and I'll rent this to you at a cheap price, because it only works once. Okay. My favorite dolls are fun. We're done. Who's next?